Welcome to this video companion to Seven Rivers Law Office's Guardianship Guide. Hopefully, it will help you to come to understand your role as a fiduciary and as a guardian of the estate better. So, you're now a fiduciary. A guardian of the estate is called other things in other states, such as guardian of the property or conservator. But whatever it's called, you're now a fiduciary. What does it mean to be a fiduciary? The word itself comes from the Latin word for trust. A great deal of trust has been placed in you. Our system understands people as existing in different ways, both as biological persons and as legal and financial entities that have possessions and investments, that may control other legal entities like corporations, and so on. This is why guardianship of the person is different from guardianship of the estate. In our legal system, for example, the person's estate continues to exist as an entity for a while after the death of the person. Because you're responsible for managing someone else's property, their estate, you're standing in a position of control over their estate. That makes you a fiduciary. Again, as the word itself indicates, this is a position of great trust and great power. This responsibility includes several duties. Think of what it means to be a good employee under a contract with an employer. This familiar experience may give you a foundation for how to think about yourself as a guardian of the estate. You are sort of like an employee working for your ward under a contract created by the state legislature and the judge who stepped in on your ward's behalf and granted you authority as guardian. Violating your duties, breaking that trust, in a sense, breaking your contract with your ward and with the legislature and court who look after the interests of people who lack capacity, could lead to serious consequences. You could be held personally liable, removed from your position, sued, subjected to criminal investigation, compelled to repay money or property, or even imprisoned. So it's serious. It's a big deal. It needs to be taken seriously, but also it's wonderful of you to be doing this for someone. So, what are your duties as a fiduciary? First, you must manage the property of the person entrusted to your guardianship, sometimes called an incapacitated person, ward, or protected person, in their best interest and to their benefit. Ideally, they would be the ones to define what that means. So, as a guardian, you guard their interests. You stand in their place and should protect and defend their freedoms and rights in the least intrusive, least restrictive manner. For this reason, for example, you're entitled to and may and should demand information that your ward would be entitled to if they still had capacity. And you should obtain any benefits, such as from insurance or from state and federal governments, that your ward is eligible to receive. And you should be ready to go to court if necessary to defend your ward's interests. Minimally, guarding their interests means doing no harm. Avoid allowing carelessness or selfishness to negatively impact your ward. But ideally, your efforts will benefit your ward, promoting their financial well-being. If your interests and theirs come into conflict, or even appear to be in conflict, you should place theirs above your own and do everything you can to eliminate the appearance of anything to the contrary. Try to understand their perspective and honor it when it's reasonable, having them participate as much as they are able in decision-making. To do this, do your best to understand your ward's abilities and disabilities, their culture and worldview, their values, their habits, and how all of these things shape the way your ward may communicate their wishes to you. Placing their interests above your own includes respecting their independent personhood, their self-determination, by defining their best interests as whatever they say their goals, needs, and desires are, insofar as they are able to rationally communicate them with your help or by consulting those who knew them when they had capacity to determine what they say their preferences were back when they had capacity. Don't substitute your judgment of their best interest for theirs if you can determine their preference, unless their preference would cause their estate substantial harm. This is known as substituted judgment. In substituted judgment, the judgment that is substituted is not yours for theirs. Rather, the decision or judgment of the best interests that is substituted is theirs back when they had capacity. So if you can determine what their judgment would have been when they had capacity, that is the judgment that should be substituted for yours. You should only apply your own judgment of their best interest when you can't figure out what they would have wanted. You should have the frame of mind of always wanting the guardianship to be as limited as possible. Indeed, you should want it to be dissolved. The goal should always be to work to help your ward gain the capacity to manage their own estate. So in that sense, you're kind of like a teacher or a parent wanting your ward to grow. For example, perhaps your ward can be given an allowance so as to have them exercise some independent use of their estate's resources while protecting the rest from misuse or waste. And if your ward regains capacity, again, actively support and seek the restoration of their rights. Perhaps they can transition to supported decision making rather than a guardianship. Educate yourself about this option. You should begin your guardianship by making sure they understand, if they're able, that they always have the right to petition the court for the restoration of their rights. You should also place their interests above those they love and care about, such as those who would inherit from their estate. In this sense, your duty as guardian of the estate is to the person and not to the estate. You should not give preservation of the estate priority above reasonably managing it to achieve your ward's goals and needs. But even if they want you to use their money or property for the needs of others, your first duty is to them. That said, you can ask those who know and love them what they think your ward would want, what your ward may have done or said in the past when they had capacity. That would certainly honor your ward's interests. As much as your ward can comprehend, you owe them a duty of candor. This means full, fair, honest disclosure of all the facts that pertain to them. Conversely, you also owe them a duty of confidentiality, keeping private facts that pertain to them from unnecessarily being revealed to others. Giving information about the ward to third parties only when doing so might benefit the ward, and certainly not gossiping about your ward. Thus, you do not owe the same duty of candor to their friends and family, and should be careful about keeping their confidence when necessary. But you should maintain communication with the person's family and friends concerning significant occurrences that affect them when you reasonably believe that the person themselves would have maintained communication with those individuals, and that this communication would not result in harm to them. You should provide information to and otherwise cooperate with any other people on your ward's team, such as a guardian of the person, since that will promote your ward's best interest. If you're a guardian to more than one person, you'll need to treat both with impartial loyalty, which can sound like a contradiction in terms, and it really can. They can come into conflict. So do your best. Your goal, if you have more than one ward, is to treat both with impartial loyalty and do your best to avoid favoring one at the expense of another. If their interests come into such a conflict that you can't be loyal to both and impartial to both, you may need to step down as guardian of one of them. You also have a duty to be careful and responsible. This means acting in good faith with common sense, being honest and trustworthy, keeping good records, and this includes holding your ward's property separately from your own. When you represent your ward in a matter, be respectful and courteous toward professionals and service providers that you work with, since that may impact the service they in turn provide on behalf of your ward. As a fiduciary, you have a responsibility to preserve and invest your ward's money and property prudently and responsibly. You need to be able to exercise the diligent skill and care of a prudent, reasonable person as the guardian of your ward. And if you have special skills, that will elevate the standard that you'll be held to. You'll need to exercise the level of skill of a prudent, reasonable, skilled person. If you cannot do this, perhaps because of a change in your life that makes you too distracted or busy, or even because your physical or cognitive abilities become diminished or impaired, you should ask to be removed as guardian. If a prudent, reasonable person would realize they did not have a particular skill that needs to be used on your ward's behalf and would seek out advice or support from someone possessing that skill, that's what you should do. Your duties are also to the court. As a fiduciary, you're an agent of the court and must report to it. You must also abide by the court orders and statutes that empowered you. You do not have any powers beyond those granted under statute by the court. Much like how a trustee, who is another kind of fiduciary, has to administer a trust solely according to its terms and in the best interests of its beneficiary, as a guardian, you're limited to the powers granted by the court and the inherent obligations of a fiduciary. You generally cannot delegate your powers as guardian, but you may engage the services of professionals to act as agents in meeting your ward's needs, though you should generally get court permission to do so, especially to ensure that you're not accidentally impermissibly delegating a guardianship power. Your duty to the court also includes various reporting requirements. Consult the checklist at the end of this guide for help with that, and the court itself can be has many resources and can be very helpful. Finally, you have an obligation to educate yourself about your duties as guardian and keep yourself up to date about your responsibilities. This guide is a good start. The appendices to this guide provide the New Hampshire statutes describing the general powers and duties of guardians of both the estates of adults and the estates of minors. The guardianship guide includes several links that you can read. In particular, there's a number of expressions that are the National Guardianship Association Standards of Practice lists areas where guardians should seek ongoing education. These include person-centered planning, surrogate decision-making, supported decision-making, factors that indicate the abuse of a confidential, fiduciary, supported, or substituted decision-making relationship, whether by fraud, intimidation, undue influence, or otherwise, legal responsibilities and duties of guardians, legal processes of guardianship, tools for resolving conflict, including but not limited to mediation and elder caring coordination, services available through protection and advocacy agencies, the role of the guardian ad litem, achieving a better life experience accounts, so ABLE accounts, and special needs trusts, and providing services in the most integrative and least restrictive setting, and including compliance with the Americans with Disabilities Act. So if any of those expressions were unfamiliar to you, that might be a good place to start with your continuing education. And finally, you have, as guardian of the estate, you're responsible for financial management and investment. So to help you with all of these responsibilities, there's a checklist at the end of this guide that might be a good place to start in working your way through that. You're doing a great thing, taking on this responsibility for someone, and Seven Rivers Law Office wishes you the best of luck.